Hello everyone, this is Attorney Raluca Hanea, and this is the third video in our series on family-based immigration. Today I will talk about conditions that may be put on visas and the difference between visas and green cards. The first video in our series explained what family-based immigration is, and the second discussed who can sponsor relatives for family-based immigration and if the sponsor needs to meet certain requirements. All of our videos can be viewed on my YouTube channel and Facebook page. Immigration terms can be quite confusing. Before explaining about conditions on green cards, I wanted to make sure you understand the difference between a visa and a green card. People sometimes use these terms interchangeably, but they are not the same thing. Visas and green cards are permissions granted by the United States government. They both are considered government documents issued by the United States, but a visa is typically part of your foreign passport in the form of a stamp. Foreign country citizens cannot enter the United States without a visa. A visa grants the holder the right to enter the United States. The U.S. government issues two types of visas: immigrant and non-immigrant. Non-immigrant visas allow people to visit the United States on a temporary basis. An immigrant visa is issued to foreign nationals who wish to settle in the United States permanently and who are eligible for permanent legal status in the country. A green card is issued to a foreign national after they enter the country with an immigrant visa. It is, as the name states, an identification card that proves a person is a legal permanent resident in the United States. Now that you know the difference between a visa and a green card, I want to answer a question I'm often asked. Is a family-sponsored visa conditional? When a visa has been issued based on marriage to a U.S. citizen or long-term permanent resident, it must be used within 6 months from the date of issuance. If you do not enter the United States within 6 months, you can lose it. In other words, you must enter the U.S. on that type of visa within 6 months after it is stamped on your passport. If you have been married for less than 2 years, when you apply for your immigrant visa, after you enter the U.S., you may be issued a conditional green card that expires in 2 years. Before the conditional green card expires, in order to maintain your legal resident status, you must file to remove the conditions. If you have been married for more than 2 years at the time the visa is granted, legal permanent residency is granted indefinitely, but your green card expires and must be renewed every 10 years. That is, if you don't opt to apply for U.S. citizenship before the 10-year terms. If you need to travel outside the U.S. while your application is pending to remove the conditions on your green card, you must apply for and obtain advance parole before you leave. If you do not, you may not be able to re-enter U.S. This is not a fast process, so you need to keep in mind that advance parole cannot be used for emergency situations. We have also heard of instances where people have been granted advance parole but have still been refused entry back to the United States. Therefore, we ask our clients to consider the importance of travel outside the United States during this period of time and refrain from travel, if possible, until you receive your legal permanent resident card. As always, we are here to help. Please contact our office to set up an appointment for a consultation. Post any questions below, and we really appreciate your likes, comments, and sharing our videos and our posts. Thank you, and see you next time.